What are the common mistakes that a Social Security judge makes in denying a claim, and why the appeals counsel can tell the judge to get it right? Now, I know that you have probably waited forever to get a hearing in front of a Social Security judge, and you were stunned when you got a decision denying the claim. So this video is going to talk about what you need to know about appealing an unfavorable Social Security decision. The approach that you have to take is to determine first whether or not the judge has committed legal appealable error. Just because the judge rules against you doesn't mean that the judge has committed error that is reversible by the next level of the court, which is the appeals counsel. Now, if your lawyer doesn't think that there is a basis for an appeal, they may advise you to either walk away from the claim or to start a new claim. And when you start a new claim, you lose your entitlement to benefits from the date of your original claimed onset date to the date of the judge's decision. But if they tell you to take an appeal, you will be taking an appeal to the appeals counsel. And one of the things that the appeals counsel can do is to remand the case and send it back to the Social Security judge and say, you got this or that wrong, you need to have a new hearing. So there are several reasons in which you may want to take an appeal. You do need to understand that the appeals counsel is going to be looking for those legal errors. So in the appellate brief that you're going to be filing, or your lawyer is going to be filing, you need to outline what those errors might be. The common reasons for a case being remanded include the judge rejecting a treating physician's opinion without proper explanation, or they may fail to discuss the medical opinions in the record, or they may not have evaluated your exertional limitations fully, or they may not have considered the full extent of your symptoms. They may have made some credibility determinations that are not really supported by the medical records. They may not have considered your psychological impairments. They may have taken improper vocational testimony. So all of these reasons are reasons potentially for an appeal to the appeals counsel. And again, that's something you should be talking to your lawyer about and making an informed decision about whether this is right for you. Now, if the case is remanded back to the judge, some will use this as an opportunity to get their denial right. Some will correct their decision. But again, this is something that you should be discussing with your attorney. Remember, you're only going to have 60 days in which to file an appeal to the appeals counsel. And if you blow that deadline, too bad, so sad. Got it? If you have any questions, call us at 727-894-3188.